you voting for? Right? You go to the ballot box, right? Well, you've got the Steve Vladeck picture, you've got the Sarah Turberville picture, you've got the Madhu picture. You can't identify what party you're affiliated with, right? You can't identify any substantive positions you hold. You can't have anyone else in the picture, right? So I guess you're voting on best picture. I don't know. All right. So in Florida, Florida goes even further. Not only are there limits on what the advertising can look like, but there's a rule of judicial conduct in Florida that prohibits candidates for judicial office from personally soliciting campaign funds. Basically, if you're running for judge, you can't ask anyone for money. So it's at this point that you should be wondering, I mean, why the hell do they elect their judges, right? If they can't really run, if they can't solicit, if they can't do anything. Well, the harder problem in this case is the Supreme Court's increasing movement to recognize that money is speech, and that therefore a state bar rule that prevents judges from soliciting money is a state restriction on speech. More to the point, it is a content-based state restriction on speech, which ordinarily gets the highest form of strict scrutiny from the Supreme Court. And the real problem that came up in the oral argument is this law is stupid, because nothing, if I'm the judge and Sarah's my campaign manager, I can't ask you for money, but guess what? She can. And so the law is not narrowly tailored, or it's dramatically under-inclusive, I guess is the way to put it. So chances are this is going to be a relatively easy lift for the court in striking down the Florida bar rule. And yet again, thumbing their nose at state judicial elections.
Was there any talk at the oral argument concerning, I feel like there's always this tension between the federal judiciary and all of, the morass that is state judicial elections. Was there discussion of that and sort of how the justices view the sort of unsavoriness of judicial elections in the states?
There was a little bit, so that was Florida's position, right? So Florida's defense, or I should say the Florida bar's defense of the rule was that, we have judicial elections, but we're trying to keep them clean. And so we should be given at least some, we, the Florida bar, should be given some leeway, right, and some latitude in trying to sort of keep as much of the politics out of this as possible. And I guess the justices were just skeptical, right, that, how do you keep politics out of elections, right? The way you keep politics out of elections is you don't have elections. And so if a state chooses to elect their judges, I think the assumption is that that choice brings with it, right, it opens the Pandora's box, if you will, to political influences. So we'll see. It'll be interesting to see what happens there. How are we doing? Everybody still awake? Excellent. All right, we're all going out for St. Patrick's Day after this, right? All right, 2 more cases that have been argued. And these are probably the 2 most important cases that have been argued thus far this term, and that have not yet been decided. So the first is a return trip of an issue that's now been in the Supreme Court 3 times. The case is called Texas Department of Housing and Community Affairs versus, oh gosh, I think it's Texas Inclusive Communities Project, I think is the acronym. This is a case about the Fair Housing Act, and whether you can bring a claim for discrimination under the Fair Housing Act based solely on proof of disparate impact. So let me back up a second. For a long time, the Supreme Court had read both the Equal Protection Clause of the Constitution and major anti-discrimination laws as allowing a plaintiff to succeed on a claim of discrimination if they could just show that the state policy in question produced a disproportionate impact, right? That whatever the intent of the policy, it produced results that were so skewed along racial or sex-based or ethnic lines that it was discriminatory. One of the most important shifts in the court's anti-discrimination doctrine has been to move away from disparate impact and toward a requirement that you prove discriminatory intent. That's indeed part of the issue of the Alabama Black Caucus case. The Fair Housing Act is one of the last bastions, right? It's one of the last major federal anti-discrimination statutes where the court has not yet said that you have to show discriminatory intent as opposed to simply showing disparate impact. And so this case has now gotten to the court 3 times. Now, it's one thing to ask the basic question of whether the statute requires a showing of discriminatory intent instead of disparate impact. What's lurking in the background of this case, though, is even bigger, which is the view that is apparently held by at least 3, and perhaps as many as 5 of the justices, that allowing anti-discrimination claims based solely on disparate impact is actually unconstitutional. This is an argument that was first previewed in 2009 in the New Haven firefighters case, Ricci versus DiStefano. And it's an argument that certain of the justices have been waiting years for the right case to consider. And so the question basically in this case is, does the Fair Housing Act authorize relief based solely on disparate impact? And if it does that violate equal protection? Effectively by allowing courts to impose remedies based on findings of racial discrimination or ethnic or national origin discrimination that are actually not proof of intent, right? Not based on proof of intent. So this is a really important case. The question, I think, is not whether the plaintiffs are going to lose. The question is how they lose. Right? Do they lose because the court says, in fact, there's no such thing as a disparate impact claim under the Fair Housing Act, which would be a really important result, or they say there is and it's unconstitutional, which would be an even more important result. So either way, this is going to be a very important case when it comes out. So that's Texas Department of Housing and Community Affairs. That was argued on January 21st. And last but not least, some case about the ACA, but enough of that. All right, fine, I'll talk about King versus Burwell. Last but not least, probably by far the most important case of the term, King versus Burwell. This is the ACA subsidies case. I suspect I don't have to tell most of the people in the room about this case, but just in case. So the Affordable Care Act has language in one of the key sections about tax subsidies that refers to exchanges created by the state. And the question is whether that language refers only literally to exchanges created by states as opposed to the exchange created by the federal government, or whether it incorporates the language of a different section that refers to exchanges created by either the states or the federal government. This may seem to be a technical question of statutory interpretation. In fact, it is a question that would if the court says it only applies to exchanges created by the state, then that means that people who participate in the federal exchange will not be eligible for tax credit subsidies for participating in the federal exchange. And what that would in turn basically produce is what's called the death spiral. Because without those subsidies, rates would go up, participation would go down, rates would then go up more, participation would go down more, and the ACA would die. There are people who want to argue that that actually wouldn't happen. I think they're optimistic. Let me say, I haven't talked that much about how the oral arguments went in most of these cases. I think people were paying a lot of attention to how the oral argument went in King versus Burwell. I think it's pretty safe to say that 7 of the 9 justices' minds were clearly made up before oral argument. The 4 progressives seemed bent on interpreting the statute the way the federal government does, which is as also covering the federal exchange. I think Justices Scalia, Alito, and Thomas are certainly inclined to say no, 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 read the statute the way it's written, and everything turns on Kennedy and Roberts. This should sound familiar. This is what happened in the NFIB case 2 years ago. The difference between the NFIB case and now is this time the chief was really, really quiet at the oral argument. He said virtually nothing. And the only sort of ray of light for the government was Justice Kennedy, who suggested that if Congress really had meant to not cover federal exchanges as well, that would really be coercive vis-a-vis the states. Because it would basically say to the states, if you want your citizens to actually have meaningful health insurance, you must participate in these exchanges. And Kennedy said, that is not what we don't usually like it when Congress does that. That seems to be a federalism problem if Congress is being coercive vis-a-vis the states. If Kennedy really believes that, if he actually means that, then that bodes very well for the government, which, to be clear, only needs Kennedy or the chief to win. However, of all the justices, the one whose performance of oral argument tends to be least indicative of how he votes is Justice Kennedy. So, pick up. That's basically King versus Burwell. I've been talking a lot. Questions? Comments? Predictions? Who's going to win the NCAA tournament? The UConn women. Just Sarah.
I saw the Hill predicted, or a columnist in the Hill today was saying 6-3
for the government?
Yeah.
So, I'll say this. I do think if the government wins, it will be 6-3. So, I don't know if you guys paid that much attention to how the Supreme Court votes. But the way they vote is they vote in reverse order of seniority, right? So, the most junior justice votes first, the chief votes last. The reason why that's telling is because by the time Chief Justice Roberts votes in this case, he'll know how it went. Right? If it's already 5-3, right? If Kennedy has already sided with the progressives, he gains nothing by joining the dissenters, and indeed if he votes with the majority, he gets to assign the opinion, right? And probably write it himself because he'd be the senior justice in the majority. If in fact it's 4-4 when it comes to him, then I think that's a mess. But I do think it's likely that if the government wins, it will be 6-3, and if they lose, it'll be 5-4. That's my one prediction. Right? It will either be a 6-3 government win or a 5-4 government loss. I feel very strongly about that. As between which one of those two, there's a reason why I'm a law professor and not a.
Well, we'll be back in the summer. Right?
We'll be back in the summer.
Hold you to account.
Indeed. So you guys are all writing this down, right? Vladeck says ... Any other questions about argued cases? No. Okay. So there, as I mentioned at the top, there are still a handful of arguments coming in April. Some of them are fairly modest or small cases. By far the two biggest are the two last that are being argued this term. First, on April 28th, it's really unfortunate that such a major case has such a difficult to pronounce name, but Obergefell versus Hodges. This is the same-sex marriage case. Basically, this was, so if you guys have been following, the Sixth Circuit, the Federal Appeals Court in Cincinnati, became the first federal appeals court since the Supreme Court's 2012 decision in Windsor, the Doma case, to uphold a state ban on gay marriage. It actually upheld 5. It upheld, Michigan's, Kentucky's, and 3 others, Indiana, not Indiana, it's the Seventh Circuit. Michigan, Kentucky, Ohio, there are 2 more. Anyway, whatever. Michigan and Kentucky are the big ones. And the Supreme Court, because now there's a circuit split, granted cert to resolve this question once and for all. There are actually 2 questions presented. The first is whether a state ban on gay marriage violates the Equal Protection Clause, and the second is whether a state must recognize gay marriages lawfully licensed and performed out of state. Unlike 2 years ago, when the court ducked to this question in the California case, right, the Prop 8 case, there is no way to duck this now. There are no standing problems, there are no vehicle problems. One way or the other, the court will decide by the end of June whether the Equal Protection Clause requires the invalidation of state marriage bans. The real question, I think, is if, as most suspect, the court says yes, that's because discrimination based on sexual orientation in general is suspect, and therefore merits heightened scrutiny, which would have enormous implications far beyond the marriage cases, which would suggest that any number of other discrimination claims could be brought by homosexuals, or whether it is a very Kennedy-esque, you sprinkle a whole lot of things together and out comes the result with little precedential value kind of case. That's the real thing I think to watch for. Right? Is it a clear holding that sexual orientation is a suspect classification, or is it a narrower holding specific to marriage? That's going to have everything to do with how big a deal it is beyond marriage, since either way it'll have nationwide significance for marriage. So that's gay marriage. And then the next day, and the last day of argument for the term, Glossop versus Gross. So very quietly, the Supreme Court has been slowly reinserting itself into the debate over capital punishment, albeit in a very strange way. So this is not like the 1970s, where the court for a time was basically supervising all capital punishment in the United States. And indeed, for 4 years, the court actually stopped capital punishment in the United States. This is different. The court is now strangely obsessed with the mechanics of capital punishment. And what I mean by that is literally the lethal injection protocol. There's a case from a couple of years ago called Bays versus Reese out of Kentucky, where the court held that, where the court basically said, you gotta sort of show quite a lot to convince us that a lethal injection protocol is itself cruel and unusual punishment. But since Bays, there have been a number of highly public and highly controversial botched executions in states using lethal injection protocols. And the justices are keenly aware of this. And so the basic question in Glossop is when, if ever, those kinds of drug protocols will violate the cruel and unusual punishment clause of the 8th Amendment. there's a lot of stuff circulating around this case, but the basic question is whether a state-specific choice of drugs and how they procure those drugs and how they use those drugs could give rise to an Eighth Amendment violation, and if so, when. And part of why I say this is sort of part of a larger pattern is the court has already granted for next term a case about whether the way Florida conducts executions also violates the Eighth Amendment. So this is a court that is clearly interested in this question, that is troubled by all of these botched executions. There have been a series of cases this term where the court has issued last-minute stays of execution because of concerns not over the innocence of the defendant, but over the procedure by which he was supposed to be put to death. And so we have this sort of weird sort of re-examination of capital punishment, not on the merits, but on the mechanics. And philosophy is going to be, I think, a very important chapter in that direction.
Well, I think there's a little bit of a distinction in gloss up from the cert grants that we saw for the Florida case. I mean, gloss up is purely about the mechanics of the execution process itself, whereas the court's grant of cert last week was related to the sentencing scheme in the state of Florida, where a jury can determine.
No, that's right. I don't think the sentences are the same.
No. But
it's odd. I mean, I get so. You guys may know Alex Kaczynski, who was for a long time the chief judge of the Ninth Circuit, and is now just back to being very powerful judge of the Ninth Circuit. So Kaczynski wrote an opinion earlier this year that it hasn't gotten enough attention, but that I could get at both of these things. And the basic premise of his opinion was we spend an awful lot of time tinkering with the death penalty. And he says, if you really are for the death penalty, then you shouldn't be bothered by the firing squad. And if you're not for the death penalty, then you're not going to be satisfied by even the most humane use of pharmaceuticals to assist in the execution of that's a bad pun, in the carrying out of capital punishment. And so he basically says, this is all stupid, right? We should put up or shut up. And I wonder if he's trying to nudge the court, right, in that direction. And that includes not just the mechanics, but also the sentencing, right? And whether, in fact, how states are imposing the death penalty is also part of this reassessment, so that the court can basically tweak the death penalty without revisiting the fundamental premise behind it. I don't know that that's really what any of the other 8 justices want to do with the death penalty, but I suspect that that's very much what Justice Kennedy wants to do. That he doesn't doubt the death penalty in general, but he's increasingly worried about the way in which it's administered, both at the sentencing phase and at the literal sort of implementation phase.
Sure, and it's certainly a practice that has become increasingly more isolated into just a handful of even counties across the United States. So I think there's plenty there for him to kind of hang his hat on.
And it's also increasingly difficult for many of these states to acquire the drugs.
Right, which is exactly how we just filed an amicus brief in the Glossop case of over a dozen former state attorneys general, several of whom are actually from states that have the death penalty, including one from Oklahoma. And the Oklahoma case is the first one that sort of deals specifically with the fact that the states are not using the same drugs that they were using in phase. And when you're executing an individual in a multiple drug cocktail, the first drug is really, really important because it's supposed to be the one that anesthetizes the prisoner. And if that doesn't work, then the next drug that's used is a paralytic, which paralyzes the prisoner, which means that you don't know what's happening when a third drug is administered, which can provide, is essentially something that would, for lack of a better way to describe it, would, kind of burn a person from the inside out. And by a lot of accounts would be a hell of a lot more painful than firing squad, right? So this is, and in this case, Oklahoma has been using this drug called midazolam, which is not approved by the FDA for anesthesia. And the cases where there's been this botch of Clayton Lockett last year, and then there was another one in Ohio and another one in Arizona, the commonality between all of them is that they're all using midazolam. And Oklahoma in particular, what the AGs are saying in their brief, which was filed just yesterday, is that the process by which a state should be adopting a lethal injection protocol is a pretty solemn one that should be taken pretty seriously with consulting of medical experts and corrections officials, people who are sort of steeped in these issues. And instead, it was a very hasty process in Oklahoma where the state's lawyers were essentially going to drugs.com, trying to figure out what might work, or calling their brethren in other states and asking, what do you think? Other states have never used midazolam in executions. And so it's actually, I think it raises some serious questions around the seriousness with which, or some serious concerns around the salinity of how states are taking sort of this ultimate responsibility of executing their citizens.
Well, I should say my favorite example in that regard is still Georgia. So Georgia's response, so Georgia had acquired, apparently, some of the drugs it was using in its lethal injection protocol on the black market. And a couple of individuals on death row sued, challenging Georgia for using basically illegal drugs. And the Georgia legislature passed a law that basically made it a secret under Georgia law, both where the drugs came from and which drugs and what they were. That was the response, right? You know, we have nothing to hide except everything. Just to sort of tie everything together, I know I've been saying that this is sort of all about Justice Kennedy. If there's one area of jurisprudence where Justice Kennedy has historically been the most, I think, left-leaning, it's capital punishment. Not in general, right? Not in a categorical opposition to capital punishment, but in sort of treating capital cases differently, in being much more tolerant of, for example, ineffective assistance claims in capital cases, of being much more suspect of states' arguments in capital cases than ordinary criminal cases. And I suspect that Justice Kennedy is going to be a bit horrified by what he gets to read in the briefs in Glossop, including the amicus briefs, that this is not going to go well for the states, but we'll see. Questions? You got all that, right? There'll be a quiz on the way out. You guys like, as long as I can bring my outline, right? So let me just say a quick word about next term. It'll be really quick because there isn't that much. Here's the sum total of what the court has granted for next term already. There are 5 cases already on the docket, 4 of which are dreadfully boring, and the 5th of which is the Florida capital case that Sarah was talking about a minute ago, Hearst versus Florida. There will be more. I mean, the court will start adding cases in April, and especially over the summer. But nothing that much to talk about yet. There are important cases I mentioned about the Armed Career Criminal Act working their way through the courts. I suspect next term we're going to see some of these many abortion cases that have been percolating their way through courts in Texas and South and North Dakota, especially, making their way to the Supreme Court on sort of the latest efforts to, among other things, impose fetal heartbeat rules on when you can get an abortion, or at least when you can't get an abortion. There's a very important military commissions case, if you're a national security fan, that will probably be up in the Supreme Court by this time next year. So it'll be another fun term, but at least so far we don't see quite the same rip from the headlines cases as gay marriage, lethal injection, and the Israeli passport case. Those seem to be the real blockbusters of this term. Oh, and the ACA. So that seems to be the story of this term. I don't know if Sarah said anything else. I'm out. So.
Well, we could give you a round of applause as a marathon student. Very helpful.
Do you guys have other questions? They don't have to be that specific. I'm happy to answer any Supreme Court-ish questions. Will anyone retire soon? No. Justice Ginsburg wants everyone to know she's doing quite well. She even has Legos now. I will say it's worth pointing out, next year, 2016, both Justices Kennedy and Scalia turn 80. So there will be 3 octogenarians on the Supreme Court by the time the next president comes to office in January 2017. I'm not insinuating anything, but actuarial tables are what they are. Take that for what you will. So I'm handing back. Yeah.
Paul, it's a tricky question. I just didn't catch the name of the Ninth Circuit judge.
Oh, Alex Kozinski, Kozinski.
Thank you.
He's quite a guy. Have you guys put it out quickly? So when you go home tonight, get on YouTube and look for Alex Kozinski and the dating game.
The dating game?
The dating game. When he was like a 27-year-old Romanian immigrant, he was on the dating game. And it's worth watching. His personality has not changed that much in the, 40 years since.
He's a colorful character.
That's one word for it. Other questions, comments, ruminations? I made it a word, ruminations. Yeah.
Not particularly relevant. when you teach,
Yeah.
Does a theme come out of your way of observing cases that you think that students might draw, given the fact that students are not always experienced enough to think about the significance of the case or the context of the case, particularly when you see this trend that continues of somewhat carelessness on the part of legislatures, particularly the Congress. I used to be counsel to the Judiciary Committee here 100 years ago, to fail to think clearly about statutory definitions, particularly with respect to mens rea and the qualities necessary to constitute crime, as opposed to simply speeding.
So, and I think every class is different. So if I were teaching a class on statutory interpretation, I think I'd want to, focus on the legislative process piece of it. I don't teach that class. I teach federal courts and I teach constitutional law, and neither can testify, neither will. I guess I try very hard to get people to see all the ways in which judicial power is really showing up in cases, right? So, when the court says someone doesn't have standing, or when the court says, we're not going to decide this question now because it's not properly presented, right? Or when the court finds a way to duck, is that an abdication of responsibility? Is that actually a real assertion of authority, right? To sort of, that it's a real exercise of power to not actually decide a case. So I try to get the students to see that there's much more to a case than just the result. And I think law students are trained that way anyway. Like, it's a common law method. We're trying to convince people to see that the opinions matter, but not just the opinions, the sort of both the tactical level and the strategic level. Why is the court doing this? Why is the author of this opinion doing this? And what does it mean going forward? Because I think the hardest thing to appreciate about, especially Supreme Court opinions, is that there's seldom only one thing going on, right? That especially in the big cases, there are usually a lot of different things, a lot of different threads, some of which are obvious and some of which are not. And I think the hardest thing about understanding the Supreme Court is to see that in cases that might, be given one sentence treatment in the headlines. That they're actually much more than one sentence. Yeah. Sorry.
I understood that Justice Breyer sometimes had written about the fact that law should sort of, to some degree, conform to changes that are taking place within society, or that there should be some feedback there. I'm not a lawyer, so I'm wondering, how do lawyers see it? How does case law fit in with changes in society, and how does that get reflected in the case law? And is that a clumsy mechanism, or is it a good mechanism that we are relying on in making policy?
I think this is an eternal debate in the Supreme Courts, especially, and in legal circles generally. So I think it depends on what exactly the question is. So I think you see much more inclination on the part of judges to look at what's going on in the world around them when they're interpreting the Constitution, and less when they're interpreting statute. Right? Because statutes are smaller, they tend to be more specific. Right? As Chief Justice Marshall once said, the Constitution does not admit of the prolixity of the legal code, and so it has to be interpreted a bit more sort of contextually. And I think the best example of that in the last couple of years, the Supreme Court had a case just last summer called Riley, which was about a very specific Fourth Amendment doctrine, something called the search incident to arrest doctrine. The idea that when the police arrest you, they can search anything that you have on you. And the question was how that applied to smartphones, given all the personal, private content we can now carry around on us in our little devices. And if you read Chief Justice Roberts' opinion in Riley, there's no way to understand Riley as being anything other than the court bowing to the changing nature of society, and especially the changing nature of technology. Every single thing about his opinion is about the ubiquity of cell phones, it's about the pervasiveness of cell phones, it's about the extent to which we all rely upon our cell phones, the volume of information we carry on our cell phones, and the very intense privacy that we may not claim, but that we sort of implicitly assume
Personal effects.
Well, but except, right, that, you can carry a heck of a lot more around in your smartphone than you could have ever carried in your backpack. And so the lower courts had said up until last year that that wasn't a meaningful distinction. And the court says, no, it is. That technology changes our understanding of privacy. So that was a very Fourth Amendment specific holding, right? That, reasonable expectations of privacy depend upon what's true of the world around us. There are other contexts where they won't care at all about what's
Tangible objects has a parallel.
Right. So I think it just depends on the context. I think sometimes they're very open to and taken by what's going on outside of the courthouse doors, and I think sometimes they are technocratic judges just doing what they do.
Yeah, on King v. Burwell, are there any kind of mixed bag rulings you think are in play?
Not really.
Okay.
I mean, it's a really hard. It's a really simple question of complex statutory interpretation. Right. That's to say, there are two answers. Right. Either the statute does include the federal exchange, or it doesn't. And there's no, sort of answer there. If it does include the federal exchange, then the federal government's happy, everybody goes away, and the ACA continues on into,
the next round of litigation.
Exactly. And if it doesn't include the federal, then I don't know that there are any different opinions to write. I mean, I think the irony is, for as complicated a question as it is, it admits of two very straightforward answers, yay or nay. And so unlike, for example, in NFIB, in the first ACA case, there's no weird, yes, it's a tax way out here. Because it is such a sort of, does it mean the federal government, or does it not mean the federal government? Right? The answer can't be sometimes.
Do you think that was a strategic decision on the part of the government, too, to sort of
Not offer a middle ground?
Not offer a middle ground, because there's, now there's all this talk about all of the millions of people that will lose health insurance, and that actually people will die if the court decides this case a certain way, and that kind of thing.
Too big to fail.
Right.
Maybe, but I guess I don't know what the alternative would have been. Right, if you're the government and you have the D.C. Circuit panel decision, right, which ruled against them on this issue, and you have the Fourth Circuit opinion, which ruled for them on this issue, nowhere in there is there a middle ground. Because it really is just a question of, did Congress mean to include the federal government, or did it not mean to include the federal government? There's no, they meant something in between. So I think it really boils down to, will the court kill the ACA or not? I think that's the one thing the media has right about the case, right? That it really is, shall the ACA survive for now, or not? And it really is that simple. That's why I think the government's in terrorem argument is actually not that unreasonable, right? I think it was the only argument they had.
Doesn't that put Roberts on the spot? Here's the guy who saved it with his.
Yeah, but and he's such a. I mean, the chief. So
if he wanted to save it then, he's going to want to save it now.
I don't know that that's true. I mean, we have a long conversation about the chief. I guess there's. I don't think it would be an intellectually defensible opinion, but there's an opinion that would be publicly defensible that says, we're judges, we interpret statutory text. It's not our fault that Congress screwed this up, as opposed to the NFIB case where it was a constitutional holding. And so I think it would be very easy for the chief to write an opinion siding with the challengers and blaming Congress. And saying, hey, if it's really a problem, guess what, Congress, you can fix it. Now, I don't know if you guys saw this exchange from the oral argument, but there was a brilliant exchange where Justice Scalia, who in his typically understated way was really playing his cards close to the vest during the government's argument. Not at all. At one point, Solicitor General Varela said, Scalia threw out the, well, obviously Congress can fix it. And Varela says, this Congress? And everybody in the courtroom laughed except Justice Scalia. So, I mean, the opinion will say, right, if they want to strike it down, the opinion will say, we're just judges, we're not policymakers, we read statutes the way they're written. If Congress wrote it badly,
It's just a small fix?
It's just a small fix. That's what the opinion will say. I think it would be deeply disingenuous, but, I don't think the chief would lose sleep over that opinion. I do think Kennedy might. Because even though Kennedy was willing to strike down the ACA at FIB, Kennedy also believes, one of his deep principles is federalism. And if you actually take federalism seriously, and not all the justices do, that actually supports the federal government here. Because the challenger's argument suggests that Congress forced upon the states a choice that, first of all, Congress almost never forces upon them, and second, might be unconstitutional to force on the states. So that's why I think it's much more about Kennedy than the Chief.
Steve, I have one. We have a little bit more time.
Yeah.
I actually have a question about what happened with the cert grant in Glossop. And so the Glossop case used to actually be captured something different. It was Warner and Glossop and the other two petitioners. But what ended up happening was that they got the cert grant, but they couldn't get a stay for Warner. And so he was executed before the cert came down. And so, and there was a lot of discussions, particularly on some of the listservs that I'm on, regarding, there kind of was like this unspoken rule previously that
The courtesy stay.
the courtesy stay, right? Because it takes 4 justices for a stay, but it takes
No, 4 for a grant.
four for a grant of cert and 5 for a stay.
Right, so in other words, right, so just to explain the procedures here, right? When the Supreme Court grants certiorari in a case, that does not automatically stop whatever was happening in the lower courts. Usually that's not a problem, right? In a criminal case, the guy is stays in jail while the cert petition is resolved. In a civil case, no final judgment is issued, etc. In a case where there is a pending execution or an election, those are the two contexts where this comes up, the E-I-O-N cases. The court will oftentimes be asked to grant a stay so that, there's some purpose to their decision. And so for a long time, for the better part of 30 years, there was a practice that if 4 justices voted to grant a capital case, where there was a scheduled execution, even a justice who hadn't voted to grant would join them in granting a stay, so that the court wouldn't be in this very awkward position of granting cert to a dead person. We have no idea why that didn't happen here. And it's possible it was an oversight on the part of the court, although that would be really weird since there are people in the Supreme Court Clerk's Office specifically dedicated toward tracking capital cases. It's possible it was an indication by Justice Kennedy or one of the other conservatives that they just, that this cert grant was over their strenuous objection.
Quite a way to object.
What's that?
Well, it's quite a way to object, right?
Yes and no. I mean, right, so if you know that there's no chance that that the petitioner is going to win on the merits, right, and that the end result is going to be that the state's going to be allowed to carry out these executions, then you may not find a moral problem with allowing execution to go forward sooner rather than later. I don't know. I mean, I'm just speculating. I think we won't know until we see the opinions, at which point I suspect at least some of the procedural posturing will make its way into the fight between the inevitable majority and the inevitable dissent. How the sausage gets made. In addition, one of the things, so there's a friend and colleague of mine, Will Vaughn, who teaches at the University of Chicago, who's been writing a lot this year about the court's shadow docket. And his basic premise is that a heck of a lot of stuff is done by the Supreme Court through its orders, right? So not through the 68 cases where it has full brief and oral argument, but through the couple dozen cases each term where it gets emergency applications for stays, or in the gay marriage cases for interim relief from the decisions below, etc. The court seldom issues opinions in those cases, but the orders themselves have a very important signaling function. And I think we will see as time goes on, perhaps increased attention to what the court is and is not doing through its shadow docket, through the cases that it's ordering some kind of relief in without written opinions. Especially, in the context of marriage, executions, and elections. That seems to be the 3 places where this is showing up the most